નમસ્કાર 11 વાગ્યાના 11 ખબરો સાથે હું છું હેતવી અને હાલના મહત્વના સમાચાર
that those getting social and educational backwardness based reservations are somehow more fortunate. This classification is plainly contrary to the essence of equal opportunity. If this constitution means anything, it is that the code of articles 15.1, 15.2, 15.4, 16.1, 16.2 and 16.4 are one indivisible whole. This court has reiterated time and again that articles 16.1 and 16.4 are facets of the same equality principle. That we need articles 15.4 and 16.4 to achieve equality opportunity guaranteed to all in articles 15.1 and 16.1 cannot now be undermined through this reasoning to hold that the theory of classification permits exclusion on this very basis. The characterization of including the poor, that is, those who qualify for economic eligibility, among those covered under Articles 15.4 and 16.4 in the new reservations under 15.6 and 16.6 as bestowing double benefit is incorrect. What is described as benefits for those covered under Articles 15.4 and 16.4 by the Union cannot be understood to be a free pass, but as a reparative and compensatory mechanism meant to level the field, where they are unequal due to their social stigmatization. This exclusion violates the non-discrimination and the non-exclusion segments of society, enabling them multiple access points to spaces they were unable to go, places and positions they were unable to fill, and opportunities they could not hope ever to ordinarily lose due to their destitution, economic deprivation, and penury. These destitution, economic deprivation, poverty are markers or intelligible differentia, forming the basis of the classification on which the impugned amendment is entirely premised. To that extent, the amendment is constitutionally indefeasible. However, by excluding a large section of the equally poor and destitute individuals based on the social backwardness and legally acknowledged caste stigmatization from the benefit of the new opportunities created for the poor, the amendment practices constitutionally prohibited forms of discrimination. The overarching principles under Articles 15.1, 15.2, 16.1 and 16.2 is that caste-based or community-based exclusion, that is the practice of discrimination, is impermissible. Whichever way one would look at it, the Constitution is intolerant towards discrimination and untouchability in all forms and manifestations which are articulated in Articles 15.1, 15.2, 16, 17, 23, and 24. It is equally prohibits exclusion based on past discriminatory practices. The exclusion made to the other than exclusionary clause negates these principles and strikes the heart of the Equality Code. The Sinnoh Commission was set up. The Sinnoh Commission was set up to examine the condition of economically backward and suggested measures, including the feasibility of reservations, to improve their law. The report published in July 2010 is based upon the census of 2001 and later surveys. The statistics NSSO 2004-2005, which the report is based on, disclosed that in all 31.7 crore people were below the poverty line, BPL, of which the scheduled caste population was 7.74 crores. That is 38% of the total of the scheduled caste population in the country. Scheduled tribe population was 4.25 crores, that is 48.4% of the total scheduled tribes of the country. 13.86 crores of OBC population, which was 33.1% of the total OBCs, and 5.85 crores of the general category, which is 18.2% the total general category. These facts established that the bulk of the economically weaker sections of the society belong to the classes described in Articles 15.4 and 16.4. I pass on to question number 2, which is that unaided private institutions, including those imparting professional education, cannot be seen as standing out of the national mainstream. As held in Pramati and Society for Unaided Private Schools, reservations in private institutions is not per se violative of the basic structure. Thus, reservations as a concept cannot be ruled out in private institutions where education is imparted. They may not be the state or state instrumentalities, state vital interest, and are not merely bodies set up to further private objective of their founders, unlike in the case of shareholders of the company. Therefore, I hold that on question number 2, the amendment is valid, but for reasons of answering question number 3, the amendment has to go. Before I sum up, I wish to address one point which the majority has dealt with, but more as a note of caution, because it is not necessary for me to deal with that aspect, which is the 50% cap. It is pertinent to note that the breach of the 50% limit is the principal ground of attack of the 76th Constitutional Amendment, 1994, which is inserted as entry 257A. The Tamil Nadu backward classes, scheduled caste and scheduled tribe reservation.
તો જે રીતનું આ મહત્વનો ચુકાદો આવ્યો છે, જે રીતના સમાચાર મળી રહ્યા છે, ત્યારે તમારી સાથે દિનેશ બાંભણિયા પણ ફોન લાઈન ઉપર જોડાઈ ચૂક્યા છે. દિનેશજી, સ્વાગત છે ન્યૂઝ 18 ગુજરાતીમાં.
बात कर रहे हैं.
જે રીતની પહેલા તો આ વિગત આવી રહી છે, અનામત યથાવત રાખવાની જે વાત અહીંયા સામે આવી છે, ત્યારે EWS સ્ટડી શું હોય છે તેને લગતી પણ વિગતો અમે આપને આપણા ટીવી સ્ક્રીન ઉપર બતાવી રહ્યા છે. આપ જોઈ શકો છો 1000 ચોરસ ફૂટથી વધુનો કોઈ રહેણાંક ફ્લેટ ન હોય, સાથે શહેરમાં 100 ચોરસ યાર્ડથી વધુનો પ્લોટ ન હોય, જેવા ઘણી બધી બાબતોનો પણ એમાં સમાવેશ થાય છે.
To agree with the opinion that the amendments, by creating a different kind of criteria, have to be viewed separately, and that Indira Sani was confined to reservations under 15.4 and 16.4 is because permitting the breach of the 50% rule, as it were, through this reasoning becomes a gateway for further infractions, which in fact would result in compartmentalization. The rule of reservation would well then become the rule of equality, or the right to equality, could then be easily reduced to a right to reservation, leading us back to the days of Champakam Durai Raja. In this regard, the observations of Ambedkar have to be kept in mind, that reservations are to be seen as temporary and exceptional, or else they could eat up the rule of equality. The fraternal principle